I think we're ready. Good morning. My name is Martin Enriquez. I am the founder of Anovven Law. It's a law firm that focuses on business and compliance and helping manufacturers, distributors, and service providers go global and succeed in global markets. Welcome to World Trade Day. I am honored to have the opportunity to present to you on a very important and literally timely topic. What is the GDPR and why should US-based companies cared? I am a lawyer, so I have to throw up the mandatory disclaimer that this is just for informational purposes only. It is not considered legal advice, and the views expressed up here are my own, not those of the World Trade Center. If you have been getting emails in the last couple of months or reading the headlines, you know or you've heard about the GDPR. It's a very complex set of regulations that the EU enacted, and I was asked to distill them in 20 minutes. And if that's not hard enough to do, I was also asked to do it in an entertaining way, or I think the quote was, "Don't do it like a lawyer." So I'll attempt to do that. These are the topics that I would like to go over in this presentation. My hope is that at least what I talk about up here puts the GDPR in better context for you and your company so that at least you understand what the implications may be for you. Now, the GDPR was enacted on May 4, 2016. We've had a 2-year transition period during which the Article 29 Working Party has issued comments and guidelines and refinements, but I think we're there. So in 10 days from today, the GDPR goes into effect. And let me take a step back and define the GDPR in case you don't know what it is. The GDPR is basically the General Data Protection Regulation. Okay? It's a significant change in EU data privacy and securities law, a change that last time they had actually enacted a law on this was 20 years ago with a Directive 95. So it's a pretty significant change. And in a nutshell, it creates just a baseline standard for companies that handle EU citizens' personal data to comply with. And it unifies under one privacy law all the member states of the European Economic Area. Now, it's important to note that the individual member states can still enact regulations that go above and beyond what the GDPR baseline is. And if I could just take a minute, the clock hasn't started yet, so if you don't mind doing that, I want to be respectful of other people's times. So what is the GDPR? I think when we talk about the GDPR, it's important to define certain terms. So the GDPR applies to personal data. And personal data is a very broadly defined term under US standards. Basically, under the GDPR, personal data is any data whatsoever that can help identify an individual. So clearly a name is personal data, but location data could be personal data. Online identifiers like an IP address can be personal data. So when we're talking about handling personal data, you have to keep in mind that it's a very broad definition. It also includes a subset which is sensitive personal data, which is minors data, biometrics data, and those trigger certain levels of compliance that are more stringent than your regular compliance requirements. Sorry. There is so much information under the GDPR, so many different levels of compliance, so many different rules and regulations that apply depending on what you do, that it really feels like you're drinking out of a fire hose. But I think if you slow it down, take it step by step, and analyze each activity that you're undertaking related to personal data, I think it becomes a little more manageable. When we talk about personal data, we also need to understand the parties to whom the GDPR applies. And those are two sets of parties. You have controllers on the one hand, which are the companies that direct the means and purpose for which the data is gathered. And then you have processors. Those are the companies that actually can collect the data, hold the data, and use the data on behalf of the controller. And in the context of that relationship, it's really important to keep in mind that the GDPR creates a set of regulations that governs that relationship. And in fact, is the controller that, for the most part, has to ensure under the GDPR that the processor is complying with the GDPR obligation. So if you use a vendor, Salesforce, for example, to process your data, you have to make sure that your agreement with Salesforce or any other processor that you're using is complying with the GDPR. So why does it matter to us? Like, why does the GDPR matter outside of the EU? Why should US-based companies care about the GDPR? Clearly, the GDPR applies to a US-based company that has a presence in the EU, right? Say you have a subsidiary. It clearly applies to your subsidiary, and if data flows to you, it clearly applies to you. But the term establishment actually was interpreted by the Court of Justice in 2015 to be a very broad and flexible term. So establishment under EU law could be de minimis. It could actually be just having a representative. So if you have a sales representative in the EU, no physical building, no other physical presence, you're going to be subject to the GDPR. But I think more relevant to the room here is non-EU companies that offers goods and services to EU citizens. If you do that, you are subject to the GDPR. So I will assume, and I'm not going to ask you, but I assume many of you, your companies have websites. And those websites are accessible from the EU, and they offer products and services that arguably an EU citizen can purchase. So if you are, in a sense, targeting EU citizens, you are subjecting yourself to the requirements, the compliance requirements of the GDPR. What remains a bit unclear, however, is if I'm a US business that sells to other EU businesses, whether the GDPR applies or not. And I think just like with any regulations, even those regulations we pass here, until some court interprets the regulations, we're still going to be somehow, somewhat left in the dark as to what are the specific situations in which the GDPR applies. The GDPR imposes some very heavy compliance burdens on companies, whether you're a processor or whether you're a controller. And those compliance requirements are called principles, and there's 6 of them. There's lawfulness, there's fairness, there's purpose, and they're too many and too complicated to discuss in 20 minutes. I think we can spend over 20 minutes just discussing each individual principle. But I think if I can summarize the compliance principle of the GDPR as it relates to a controller, it's as follows. Collect data for the specific purpose for which you're going to use it. Tell the data subjects, the EU citizens, that you are collecting the data up front when you do it. And when you're done with the data, when you're done using it for the purpose for which you collect it, get rid of it. That's a way to summarize the principles of the GDPR. And let me give you an example to sort of illustrate how that works. One of the quote-unquote lawful basis for collecting data, one of the lawful basis I can use to collect data is to fulfill a contract. So say I have a website and I'm targeting EU citizens. Maybe my website has a flag German. I can go on there in Germany and click on it and read your description in German and buy your products. Well, you're going to collect my name, my address, and my payment information. And you're collecting that data to process the order, to fulfill a contract. That's a lawful basis for which you can collect the data. But say, for example, for whatever reason, you also want to know my age and my gender. Well, the reality is that neither my age or my gender relates to or is necessary for the purchase of this product. So if you're going to collect that additional data to profile me based on my purchases, then you're going to need a separate lawful basis for collecting the data. Because fulfilling the contract, you don't need sex and age to fulfill my purchase. So again, very specific reason for why you're collecting the data, and you have to tell me up front that you're doing it. I purchased, and let me give you a US example. I purchased a ring, an engagement ring, about 3 months ago. And I threw it in a drawer. I was going to go to London for work this past week, and I was going to have some vacation time in the end, and decided to go to Barcelona and took my girlfriend to Barcelona. So when I purchased the ring, I gave him my name, address, and payment information. Well, went to Barcelona, got proposed. She said yes. Thank you. And got back home, and 2 days later, I kid you not, I go to get the mail, and there's like a pile this high of just like wedding-related catalogs. And I'm like, where did this come from? So in the EU, right, clearly the jewelry store took my data and sent it somewhere else, and it was sold or whatever. In the EU, you couldn't do that because profiling me for wedding stuff was completely unrelated to your ability to sell me the ring. All right, so the company would have had to have another lawful basis for collecting the data. On the other side of that coin, the GDPR imposes compliance obligations on companies. It also grants individuals greater rights over their data. Again, just like the principles of the GDPR, there are just way too many rights to discuss in 20 minutes. I mean, the GDPR is over 100 pages long. But I just want to highlight some of them to give you a sense of what individuals can do and how you have to comply. I think the most important right that individuals have under the GDPR is the right to be informed. When you collect the data, you have to tell them up front. And I think we've all been seeing this, right? You log into Twitter, or you log into Facebook, or you log into any other website, and all of a sudden says, well, we changed our terms and conditions and privacy statement. Click here if you agree. And it almost makes you click there in order to proceed with viewing the page. That is basically the right to be informed. You're telling them, when you come to this site, we might be collecting information in the back through cookies, or if you're going to purchase something, this is what we're going to take. And this is why we're doing it. So you have to give individuals information about how you're collecting the data and why. Another right that individuals have is the right to access their data. Say I suspect that this company has my data because I just got a catalog. I can request access to my data, that it be given to me, so I can verify why they're processing the data. There is a right to rectify, meaning that I can access the data and complete the data if it's incomplete, or correct it if it's wrong. And I think importantly, there is the right of erasure, so-called right to be forgotten, right? Under certain circumstances, I can request the company that my information be deleted. I mean, these are all standards that really don't exist under US law, but that now US-based companies selling or offering products and services in the EU will have to comply with. And the compliance comes in the form of privacy statements, by telling people what you're doing, and having policies in place so that when you get a request to rectify my information, that you have policies in place to follow that request, and that you have processes and policies in place to record your compliance, because that's a key aspect of the GDPR. So you have to demonstrate that you are compliant. You can't be passive about it. You have to affirmatively demonstrate. That's why we're seeing all these changes to the privacy statements, because we're showing up front, this is how we're complying. The privacy statement and any other document that you use to communicate individual rights has to be concise, has to be transparent and clear, has to be written in plain English. Particularly if, say, you're an app developer and you target minors, you will have an additional requirement to make sure that your terms of use and your privacy statement reads in a way that a 15-year-old or a 16-year-old or a 17-year-old can understand it. And the age of compliance or the age of consent, will change from country to country, so you need to be aware of that as well. So everything that we've been talking about applies to both an entity in the EU, how they collect and use the data, as well as entities in the United States that collect and process data. So let me give you a real-life example, because I have a client that I'm working with that has this situation. You collect data, you have affiliates in the EU, you collect data. The data lives in a server in Ireland. The moment the US entity accesses the data, it doesn't have to be sent to me, The moment I access the data on my computer here in Denver, Colorado, I've exported the data to the United States. And the GDPR imposes some restrictions on how data, personal data, can be moved out of the EU. And there's several of them, some of which Don't necessarily apply to everyone, but I think they're worth discussing. So I think the most basic one is an adequate decision. That is, the EU Commission made a decision that a country's laws and regulations are stringent enough that companies in that country that have to comply with the law offer an adequate level of protection under the GDPR. Countries such as Canada and Australia have those kinds of laws. In the US, we have the so-called Privacy Shield. The Privacy Shield is an agreement between the US Department of Commerce and the EU, pursuant to which companies here in the States can certify that they're going to comply with the GDPR principles and requirements. When you do that, you're also subjecting yourself to the jurisdiction of the US Department of Commerce, meaning that if you are found to have violated a GDPR principle, the US Department of Commerce and the FTC in particular can enforce that law against you. That works for certain companies. It's an annual requirement that you have to comply. Another method for moving data out of the EU is through binding corporate rules. This is a case where you have an affiliate. Say you're the parent company here in Denver, you have an affiliate in Germany. The affiliate collects data, personal data information from customers, but you need the data here in the US to process it, to analyze it, or for whatever reason you stated that you need the data. You can have binding corporate rules where, as a company, you both agree to be bound by the GDPR requirements. Another mechanism to move data out of the EU into the US or elsewhere is through standard contractual clauses. Now, standard contractual clauses were clauses that were drafted by the EU Commission under the Directive 95 and basically set forth a mechanism by which data can be moved out of the EU and what your obligations for compliance are to offer that level of protection. Companies are still using those. They're just adding an addendum to them to make them GDPR compliance because you, like I said, in your relationship with your vendors, you have to outline what the requirements under the GDPR are for that relationship. So it works under certain circumstances, but the problem with the standard contractual clauses, as I said, they are clauses from the Directive 95. The Article 29 working party is actually working on drafting guidelines, and eventually we might see some standard contractual clauses, but there's still some ambiguity as to the lawfulness of them under the GDPR. Another way of transferring data out of the EU are through exceptions to the GDPR rules. I think relevant to this room, for example, going back to my reason for collecting data, if you are processing a contract, that's an exception to these restrictions on transfer of data. So again, GDPR is a complex regulation, but when you really boil it down or when you really think about what you are doing and how it applies to you, I think you can find some very workable mechanisms. So if I'm collecting data in the EU to process a contract to sell you goods, I can take that data out of the EU for the same reason, to fulfill the contract. Okay? But if I'm taking also data such as age and gender that have nothing to do with the ability to fulfill the contract, then I'm going to need another lawful basis for transferring the data. Maybe it is a contractual clause. Maybe if my subsidiary is collecting the data, I can do it under the binding corporate rules. But the important key is you have to have a lawful basis for taking the data out of the EU. So why is this important? It's important because the fines under the GDPR are substantial. There's a maximum penalty of 20 million euros or $22 million, or 4% of your global or global revenue, as a company. So compliance, they thought, look, if you're going to come and do business in the EU, which is a significant economic area, you're going to have to abide by our regulations. And in order for us to make you do that, we're going to incentivize you to comply, because if you don't, you're going to be subject to some serious fines. The reality is, and there's still a lot to be determined under the GDPR, how aggressive are the authorities, the supervising authorities in the individual member states, how aggressive are they going to be? I was in a conference 2 weeks ago of privacy professionals, and there were some supervising authority individuals there, and they say, look, the reality is this is complex, especially for you in the US. We understand that you've had a time to transition, but what we want to see is we want to see a good faith effort of compliance. So the takeaway is you might not have it all down. It might not be perfect, but you have to at least demonstrate a good faith compliance effort. And that could be through revising your policies, giving some thought to what you're doing. So we got 10 days. What can we do to get ready? Well, take it seriously. They take it seriously over there. They describe it as a fundamental human right, a term that we here in America do not associate with your personal data. We give our data away. How is it a fundamental personal right? But that's how they define it. So take it seriously. Look at, do an assessment. How does your data flow? Like, where is it coming from? Why are you collecting it? What's the purpose? What are you doing with it after you collect it? Revise your policies. Seek outside help if you need outside help. Train your personnel. Read up on it. All those things you can do to at least make a good faith effort to comply with the GDPR. And lastly, just stay calm. As I said, it's a process. It's not a quick fix. And so you have to take it step at a time to get compliant. But make an effort to do that because that's what they want to do, because otherwise the fines are pretty significant. I do have a couple minutes for questions if you want to do that. And I know that it's, when I was asked to distill the GDPR in 20 minutes, I'm like, there's just no way you can do that. So what are the key issues that I can highlight? So I hope that at least it put it in somewhat better context for you. Yes?
Thanks. Thanks for this presentation. It's been a long way since 2016. My question is, when you try to purchase something, they often have that, are you in agreement with our regs or our regulations or whatever they say there, and then you almost are blackmailed into pressing that so you can purchase whatever you want. Is that continuing in Europe? And is that seen as a legal way of being in compliance with their long agreement that no one really reads in the future?
Well, and that's the reality of it. I mean, unless you're in the business of data privacy, you're not reading privacy statements when you go purchase something. But it is the mechanism by which you get people to agree. So another way to collect data and also transfer it, because you have to analyze each situation different. There's a way to collect it, and then there's a separate way to transfer if you need it out of the EU. Consent is a way to do it. So I may say to you, look, if you're going to buy products from me, you have to consent to me taking your name. I mean, in that scenario, it's a bit unnecessary because the fulfillment of a contract is a lawful basis for having your data. But consent could be the data for the basis for exporting it. So I'm going to take your data to sell you the product, but you're agreeing to the terms and conditions when you make this purchase, which include you're agreeing to me sending the data to a CRM here in Denver. So you can definitely, I don't want to use the term compel, but get them to consent to you using their data and to transfer it too. So